Ladies and gentlemen, we will just wait for a minute or two just so that participants can log in as they are now logging in. So just bear with us for a few moments. Right. Well, my name is Raphael Tay. It gives me great pleasure to to welcome all of you to this first session of the IPBA webinar sessions for the year 2022. Today's session, we are going to talk about the internationalization of legal practice, whether it's a reality or a myth. With us, we have very eminent group of speakers, panelists, whom I will introduce in a moment. Meanwhile, just want to invite the opening remarks by President Jack Lee, the President of IPBA.
Dear distinguished colleagues and guests, Happy New Year! I thank IPBA officers for organizing this timely seminar, taking place under the devastating impact brought out by COVID-19 pandemic. I do appreciate the joint efforts and collaborations from all members and officers working for IPBA during such a difficult time. The legal landscape has changed tremendously in the recent years, with lawyers increasingly participating in international engagements, and typically domestic law firms similarly deploying internationalization strategies. In many ways, the concept of internationalization of legal practice has been in subsistence for decades and remains impactful across the legal profession. In this first IPBA 2022 webinar, we will explore the trends and evolution of the realities or myths of internationalization of legal practice, along with qualities and skills required for members of the legal fraternity to embrace this transition and evolution. Today, we will have prominent speakers and moderator to share with us about their views on today's topic, internationalization of legal practice, reality or myth. Finally, please allow me to share with you the English lyric of our first IPBA song. You were born in Asia and grew up in the world, with different blood but common pursuit. Spirit of Kazawura, heart to heart, hand in hand in wisdom, love and sincere forever. We are the spirit, IPBA. We are the family, IPBA. We are forever, IPBA. We are together, IPBA. I wish this event a complete success and wish you all a happy and peaceful new year. Thank you.
Thanks very much. That was President Jack Lee, President of the IPBA. Ladies and gentlemen, good morning to you, or good evening to you, or good afternoon to you, wherever you may be. But I would like to introduce our three panelists for this afternoon. Beginning right in the Americas, from Chicago, I'd like to welcome Michael Chu from the United States. Michael Chu, whose illustrious career with McDermott, Elliott and Wills has been in practice for a good number of years, so many years that I dare not ask him how long now. But Michael is a good friend. He's also a patent lawyer, a IT lawyer, and both in advisory as well as in dispute resolutions. He's a current nominee for the Vice President for IPBA 2022. Moving towards to the United Kingdom, Giles Proctor. Giles Proctor is the CEO of the College of Legal Practice, a educationalist, a lawyer, eminently suitable and suited to talk about the skills and the trainings that would be required of a young lawyer or a lawyer that is planning to enhance their skills in this area. And finally, we have Lee Hock Jun. Lee Hock Jun is a lawyer practicing from Auckland, New Zealand. Someone who has had also a very illustrious career. He is a partner in the commercial property team, as well as he heads the Asia practice at Herkish Hendry in law firm based out of Auckland. One of the interesting things about Hock Jun is, of course, he is Korean by ethnicity, but he is a New Zealand citizen, having been brought up in Auckland, and therefore he shares some, even from a just personal cultural perspective, a form of internationalization that, of course, also applies to Michael Chew. Michael Chew, I will leave it to him to tell you whether he was born or brought up in America, but certainly he is as American as you can get. As well, he has got a very international career, having met Michael Chew and Hock Jun through the IPBA conferences for a good number of years. Today's topic is really about the internationalization of legal practice, reality or myth. I think one of the first questions that needs to be answered is, what do we mean and what do we understand by the internationalization of legal practice? And what are some of the examples when we talk about internationalization? What are they? Are we talking about the practice of international law? Are we talking about purely advisory, consultancy, or corporate issues? Or are we also talking about arbitration, dispute resolution? Does it apply to the concept of the internationalization of business transactions that has come out and about because of the globalization of business transactions? So these are some of the issues that we will be exploring as to what do we understand by the internationalization of legal practice. What is perhaps later on, I hope through this discussion and this conversation, the panelists would also share about what are some of the skill sets that are required for someone who wants to be involved in this area of practice. What are some of the current trends in the internationalization of legal practice? What are the common trends in terms of what law firms are doing in order to enable to service their clients throughout the world? In terms of skill sets, we will be talking about what skill sets that will be required. Would legal design skill sets be important? Would legal project management be relevant? And so some of these things, I hope that will be brought up in the course of our conversation and discussion this afternoon. So to begin with, I just would like to ask this question. What do we understand, or what do you as a panel, as panelists understand by the internationalization of legal practice? And what are some of the examples you can share, drawing from your personal experiences? I will start with Michael, and then, Giles, Hock Jun, please feel free to enter into the conversation. Michael.
Sure, Raphael, thank you. And it's good to see everybody, and welcome to the conference. I think, Raphael, this is a very important question. I'm glad that you brought it up, because as we were on the panel here preparing for this seminar, one of the things we all realized is that we weren't sure exactly what it meant because, Raphael submitted and we had the title for this conference many months ago. And we had talked about it sort of broadly. And then we, as we approach the date, I'm looking at the title of the conference, Internationalization. And I realized that I had a point of view as to what that meant that I think might be different than what other people think of it as. In the United States, I think the word internationalization is not used in the context in which we're talking about, I think what we're talking about is everything you said, Raphael. It is the practice of law going beyond the border in which you live or the citizenship that you have or even the bar admission that you have, the qualifications that you have. It is bringing your practice more internationally wherever that may be. So if you're based in the Pacific Rim, bringing stuff towards Europe, bringing your practice towards Europe or towards the United States, North America, things like that. And then, of course, the opposite from those of us here in North America. So to me, I view it as really expanding your practice towards the international arena, which from a linguistic standpoint, if we go back, I guess that is the word internationalization, but it hasn't been used that way. Anyway, we can talk about specifically how that happens, but that is my understanding, and it can cover a lot of things.
Thanks, Michael. Giles?
Yeah, thank you, Michael. I think that's absolutely spot on. I would add to that, I think, from our vantage point in London and seeing how the firms operate out of London across the globe, I think there's an increasing sharing of common practice. I think when I look at internationalization, and maybe I'm looking at it with my educator's hat on, I'm seeing common approaches to legal practice springing up around the world. And that may be because obviously best practice is something that law firms always are looking out for, but also as law firms expand geographically, I think they take with them into international jurisdictions different practices, which maybe local lawyers look at and think, actually, that's something we should be doing. So from my sort of educator's perspective, there's always that idea of a growing sharing of practice, of good practice across international law firms. That's sort of where I come from initially on that.
Thanks, Giles. Hong Jun.
Yes, I agree. The concept of international or internationalization in the legal context is very confusing. When someone say, I want to be an international lawyer, or I want to practice international law, I always thought what they really meant by that, international lawyer. So to me, I think it's important to differentiate the practicing international law and having a legal practice, having a practice of a international legal practice. If you're saying that if you practice international law is based on the multi-jurisdictional treaties or agreement or convention. So you should be really working at like a UN or a more international organization. But having a international legal practice means that I think to me it means that you still practice domestic law, but in a more context of a global business. Mm-hmm. So your clients, obviously multinational clients who need legal advice from different jurisdictions, different countries. So to me, international practice means that you are still practicing domestic law, but in the context of a more global and multinational business context.
Thank you very much. For introducing the concept of you are still practicing domestic law. That, of course, is a given, and that's why when the question of whether or not you have to have special qualifications to be able to practice internationally, really, I think that's conceptually the wrong question to ask. But I think that's something that Giles may want to jump in and speak a little bit more about later on. But what I want to ask the panel now is this. Whilst it is true that even when we talk about the internationalization of legal practice, we are really talking about the practice of domestic law serving international clients, perhaps. Mm. But I would like Michael's opinion now, as well as Giles, perhaps from the City of London. To both of you, there are many global or international law firms, the Magic Circle law firms of London, for example, and there are lots of Anglo-American international law firms that you hear of and are aware of. How then would they practice when their clients are in London, but they have multiple acquisitions throughout the world, right? It could be in China, could be in Myanmar, could be in Korea, or it could be in India or the other side of the world, China, for example. This Anglo-American firms, whether it's out of Chicago, New York, London, also be managing that acquisition. Your thoughts, and perhaps you could just explain how it would be done or is done. Michael, perhaps.
Sure. I think at the outset, I think it needs to be said that I especially for our young lawyers who may not know, or even young non-lawyers who don't know, I don't think that there is no degree or license that you can get to practice internationally. It's not like okay, I have this special license that I get in Singapore and it allows me to practice in 15 different countries. It doesn't work that way. At the very most, there are some individuals that maybe hold dual citizenships and perhaps dual licenses. What comes to mind is perhaps like Ben Rishi or something that from Japan who holds a license, and sometimes they have a degree and a license in the United States. Sometimes that happens, but it's not much more than that. Anyway, within the context of your question, I think large law firms tend to be networks of offices around a certain locale, country, or the world. And I think the practice of law, someone's individual practice, or the owner of a license for a practice is really that license is really specific to that individual. So an individual, as I mentioned earlier, is going to have a license to really one jurisdiction or one country or one area. And if that individual works at the firm is really a network of those individuals, and those individuals are in those offices, and the offices are their own networks. So for example, we just opened up an office at McDermott. We opened up an office in Singapore recently, and those are Singaporean lawyers, Singaporean licensed, and they practice, that is an entity of a law firm that I think existed prior to becoming part of our own firm network. They, I believe, are partners of the firm, or will become partners of the firm. So they are part of the social landscape of the firm and the internal landscape. And there are various other things that we can share, I believe, with some of our foreign offices, including in the UK and Europe, that share, for example, the attorney-client privilege. Other things like that. We're allowed to do that through various cooperative legal regimes that allow that to happen. That said, just because I have clients in Singapore does not mean I can practice Singapore law at all. But I know, and I have a connection with, and I share a billing arrangement with, and I share an internal communication system with, from a technology standpoint, our office that's in Singapore. So that's how a firm does it with all the various offices and things like that. I think I'm answering your question.
Yeah, sure you did, Michael. Just one question, Michael, if it's not privileged. Is this law firm McDermott in Singapore? Does it go under the same name, or is it a different name?
So it's interesting. I'm actually not sure about the one in Singapore, because I think it's still looking to be officially open. But I believe when we have offices in other jurisdictions, I was using Singapore as an example because I'm looking at you, Raphael. But in other countries and in the UK, it does share the name, and it previously had offices in China as well, and those shared the name, but it was more or less sort of a trademark that covered the firm and sort of identified the two sources. But I think technically speaking, it wasn't an official partnership. At least the China office wasn't an official partnership. It was more of an alliance.
Sure. Okay. No, I asked that question, Michael, because in some jurisdictions, like in Malaysia, for example, foreign law firms are not technically permitted to establish offices in Malaysia. There are a couple of exceptions, of course, but generally speaking, it's quite difficult to enter into the market. So I see a lot of international law firms entering into domestic markets via collaborative agreements, that sort of thing. Giles, your thoughts?
Yeah, that's very much the case in the Northern Hemisphere in terms of the UK. Looking at the practice of firms based here, I think it's the decision is, do you open a branch of the firm in another jurisdiction, or do you actually go to some firm that's already established in that jurisdiction, has a reputation, and as Michael says, go for the cooperative approach and share services. Interestingly, of course, in the UK, we've just left the European Union, and within the European Union as a whole, whether that's a good or a bad thing, we won't go into that. It's another seminar altogether. There is that passporting ability within the European Union of legal services within each country, which was always a very interesting idea for law firms based in the UK. I suppose one more point to add to what Michael said, and back to our point about licensing. Yeah, dual licensing is something that certainly in the City of London, lawyers have looked towards New York Bar, often as a point of license, or maybe qualifying in the state of California, as well as obtaining the qualification to practice as a lawyer in England and Wales. And that's a trend that's continuing, even with the new regime now bedding in. You'll see a lot of lawyers in London looking to the New York Bar as their sort of dual qualification.
Yeah, thanks, John. Hok Jun, I want to ask you this question. I don't know whether you're aware of this, but I'll try. You being Korean. I noticed a lot of Korean lawyers in Korea are dual licensed, and typically it is the American bar, which is the New York bar, typically. Is there a reason for that?
I think there is a couple of reasons for that. Number one is that Korea is a civil law basis. So the lawyers in Korea never had an opportunity to exposure or experience in the common law system. So the top law firms send their elite lawyers to America to experience the common law system. And that's number one. Number two is that it's kind of like rewarding. You pass the bar exam, you working hard for the company for 10 years, that the company as a appreciation of their contribution of hard working, they as a reward, they send one or two lawyers, elite lawyers to the USA to get the qualification. That's like a bonus. Number three, I think Korea is heavily dependent on the American trading. So America is a big, their trading allies and big market. So it doesn't really mean that you have an American New York bar qualification, you can practice American law. It just to give the clients, the Korean clients, confidence that he has some sort of experience in the USA. So the clients can confidently instruct the lawyer, engage the lawyer who has some understanding of American law. Yeah, I think that's the main reasons. Yeah.
Or at least perceived to know American law.
Yes. Yeah.
Right. This begs another very interesting question. I noticed not just in Korea, but in many other jurisdictions. Thailand is another jurisdiction that I noticed, that a lot of Thai lawyers would have dual admission in American bars, which is typically the New York bar. But the question I'm going to ask, and Giles may want to jump at this, I don't know, Giles, but the question I'm going to ask is this: why would a corporate commercial lawyer, a transactional lawyer, want to learn from the American bar, whether it's New York bar, Californian bar, whatever it is, principles of litigation as opposed to transactional law? Is that really relevant training?
I mean, I'll obviously, yes, I'd love to jump in, Raphael, and obviously I'll defer to Michael as well. He'll have far more expertise in this area. My view from talking to firms and their approach to training in the City of London is that when they are training their commercial lawyers, obviously they are acting in international transactions. Anglo-American law is a very strong force in those transactions. The agreements, in terms of Anglo-American contracts. The law, the approach is one that's very similar. And I think that they want their lawyers not just to be able to advise clients on the purely commercial and what we might call the corporate aspects of any deal, but also to have that wider understanding of, well, what are the clients thinking about? What are the risks here? Do you understand the risks of litigation in a particular jurisdiction? Do you understand what the costs might be to your client of a particular commercial arrangement? And I think that's why at the New York Bar, if you're working internationally and you're working on these contracts, which are very, very similar in terms of structure and approach, you also need to understand the wider hinterland of the risks to your client and the issues that fly around. Michael, does that sound sensible to you?
Yeah, completely sensible, Giles. You're exactly right. And I think it's also, you want to be able to give your clients advice on laws of various jurisdictions. You need to have sort of a basic knowledge. And we say here in the United States, you need enough knowledge to be dangerous, but not enough knowledge to hold yourself out as really being an expert, right? Because that's against the ethical code here. Yeah. But you want to know, like if your client, if an Australian client asks, well, why don't we just sue them in the United States? As an Australian lawyer, it would be good for you to say, well, you can do that, but it's going to be tremendously expensive because the discovery process there is much different than it is in Australia. For example, 1, 2, 3, 4, so that they know sort of the basics. They can't give actual advice, but they need to be able to help survey the laws that are likely, that your client will likely run into. Sure, you could call, you could call me in the United States, you could call, Hawk in New Zealand and all these other jurisdictions one by one, but that would be expensive and tedious. So,
your thought.
Also, in some countries like Korea or Japan, having a USA qualification that spent 1 or 2 years in USA, the clients appreciate the lawyer has that ability to speak the English fluently and understand that having some sort of a cultural competency as well. So if you have only domestic experience, you may be not exposed to the many like a foreign jurisdiction and cultural differences and some sort of different legal system. So I think clients find it a little bit comfortable having some foreign, especially USA qualification. The lawyer has not just the legal knowledge, but also the cultural competence and the language skills.
Sure. Yeah. I think that's something that we will touch on a bit later. I just want to move our conversation, our current conversation, to the area of why are we seeing increasing efforts in internationalization of legal practice? Having defined what we mean by internationalization of legal practice, why are we seeing these efforts? And what are some of these efforts? Anyone?
I would jump in and say very simply, it's client-led. I think the law goes where the client goes. And clients are increasingly looking globally in terms of expanding their operations. They're making use of the new technologies. They're making use of the time zones to work more effectively across time zones and using international law firms to do that. And I think ultimately we will always be, as a profession, client-led. And if the clients are going international, Raphael, we will as well.
Yep, I completely agree with that. And what Giles said, even expanding that, if it's client-led, when you're developing a practice in law over a period of years, especially within a specialty, you tend to gravitate towards one sort of compartment. So for me, for example, it's patents litigation. Sometimes if it's patent litigation relating to medical devices or something like that. And a lot of the clients in the area say, well, the focus of our manufacturing is in Brazil, or the focus of our manufacturing is in Taiwan. And so many questions of the factories and the manufacturing tends to center around Taiwanese stuff. And then before you know it, you become an expert, and you want to seek better knowledge of the law of those foreign jurisdictions. And so you become an expert just sort of naturally, again, client-driven.
Oh, yeah.
And also, if you're just looking at the domestic legal market, there's always big competition, and sometimes it's very saturated market. So you can, if you want to diversify your practice, you know, that international practice is always good source of getting the new clients. And if you happen to be in a country where the foreign investment is coming in, I think you should consider having a practice, international practice as one of your source of clients. Because the cross-border transaction tends to be bigger in terms of scale and normally generates bigger fees. So I think there is a good opportunity here, just rather than focus on the domestic market.
And I think it's important for our younger lawyers to understand that the ability to call upon expertise, you know, in various jurisdictions is very important, and to have sort of at your fingertips people that are experts in those various regions, right? So Raphael, I would give you a call in Singapore, and I have given you a call relating to various matters, and Hak, you know, in New Zealand, and Giles in the UK. If there's questions I have on specific matters, you have your network there, and a lot of this network is built through organizations like IPBA. And I think joining an organization like this is one of the most important things that you can do. Sure, you can choose to not become an expert in certain areas. You know, you don't have to hold yourself out to be a practicing, like I don't have to say I'm a practicing New Zealand or Singapore lawyer, but it's good for your career to sort of learn about it and have a network of people that you can really readily call upon. And I think that's important, a little bit of a sales pitch for IPBA, because I think it's very important.
Yeah, gentlemen, I think I totally agree with your comments and your thoughts, but that is based on the assumption, Giles, that your client would want you to be guiding them and leading them in a foreign jurisdiction. Am I right?
Absolutely. And I think in a way, again, if you look at the clients, they're quite hard-headed, and their approach is, well, what's it going to cost me? So always think about the cost of the client. And if they can come to you as the source of the expertise, to then reach out, as Michael's pointed out, to your network to get them advice that's quick and efficient and accurate, then they'll be using you as their sort of interface between the organizations overseas they need to work with. It's much better to go through you as an international lawyer than to go to individual organizations based in different jurisdictions, establishing separate links with each of them. That costs more money and time.
Absolutely, I totally agree with you. But that also then presupposes that you, as a domestic lawyer, number one, either have those networks or are in an international law firm, or have any inclination even to be able to do this.
Yes.
Right. Therefore, what are some of these skills that these lawyers, whether they be young or those that have been in practice for quite a number of years, that are trying to get into this practice area or to get into this area of practice? So what are some of the skills that you gentlemen think would be important? I think, Jun, you started off by saying cultural fit, right? I think that's very important. So you want to talk about cultural fit as a skill, as a ability?
Yeah, I mean, as a lawyer, I think you already developed your legal skills. So if you want to expand your practice to more international arena, what do you need? I think number one is cultural competence. And you never underestimate that you have also language skills. It is not just understanding the foreign law. I know a lot of countries, especially in Asia, a lot of resources are still not in English. So if you have that language, we will definitely help you to understand the foreign law better. But apart from that, cultural competency, how to develop the network, how to make friends, how to sensitively approach your clients in a more diverse clients in a different perspective, and how to manage your clients. So this cultural competence can give you certainly more advantage in terms of managing overseas clients and also expanding your practice internationally.
Yeah, actually, that reminds me. Yes, in the English language means yes, but in English, but in some spoken in some parts of the world, yes doesn't mean yes. The nodding of a head doesn't mean yes. I mean, it could mean something else.
Yeah.
Michael, sorry.
Some countries you need to at least ask 3 times to make sure you really understand what client wants.
Your experiences, Michael.
I think what Hakjun really covers so many things. I think that's absolutely right. I mean, the language is a tremendous advantage, but you don't have to have the language. But a cultural understanding, perhaps most importantly, even if you don't have a cultural understanding, you have to have a willingness to listen and be ready to absorb it and understand it and understand that culture as a learning experience. Because I think, you know, sometimes lawyers can be very aggressive and say that I'm right all the time and not sort of want to bully their way into another culture or another jurisdiction and say, no, this is the way it is, when it really isn't the way it is. So you have to be willing to learn. And I think for some lawyers, that is going to be difficult. But I think it's absolutely necessary in the international arena.
Mm-hmm. Giles, how does the English or the European lawyer stand in this arena, in this area?
I think picking up on Michael's point of listening and being able to listen, and 2 points that young lawyers we talk about as we take them through their qualification. Firstly, it's about being able to understand that while you will know all the law, and young lawyers are always very keen to know the law and repeat it at length often, listen to what your client wants. What's coming back from your client? So your client won't want the 5-page document about their practice or what they're doing. They'll want that 3-line piece of succinct guidance based upon the legal work you've done. So always think about the client and what they want. And the second thing, it's a word that flies around a lot for young lawyers in the UK anyways. Are they thinking about their brand? What is your brand as a young lawyer? You know, are you part of a great network like the IPBA or other networks? Are you consciously talking to your peers and learning from them what they're doing in their particular careers? And are you thinking about your practice, not just as something you learn more law, but the skills you're using around that practice? Are you able to manage client relationships? Are you thinking about different approaches for different clients? And are you looking beyond almost your law books and looking into what the client really wants? I think that those are always things that come through constantly when we're talking to young lawyers about how to develop yourself as a future practitioner.
Giles, apart from having a good cultural understanding and sensitivity to other ways of doing things in other jurisdictions and other cultures, one of mutual respect, for want of a better word, what are some of the other skills that you think would be required to be able to practice law internationally?
I think I would highlight 2 in particular: a real understanding and appreciation of technology. And by that, I don't mean being technically whizzy and being able to use software, etc., but understanding what clients are using. So increasingly, as we talk to law firms, they are concentrating very clearly on, well, what are the simple technologies that our clients are now using to make their business more efficient? Is it, for example, when you're doing a commercial deal, are you now using data rooms to gather the information together that's needed for clients? And also in the offices, what technologies do young lawyers need to master? You need to have a working knowledge of whether it's Word, whether it's Excel, whether it's data management tools. So what do you have to learn as a young lawyer? Those technological skills are becoming more and more important. The second skill I would say is understanding finance, a simple understanding of how a business works. And that can be as simple as being able to take a set of company accounts and make sense of them. Now, that's something you can bring your skills level up very quickly by doing that. But actually, again, when you're talking to clients, they're always thinking about their bottom line. They're always thinking about their financial position. So therefore, as a young lawyer, you must be able to at least understand simply the financial mechanisms and levers that they're thinking about all the time. So those are two areas of skills I think young lawyers could really benefit from working on.
Michael?
Yeah, I agree with that, especially the business and what Giles just said, understanding the business of the clients, because people's businesses in different areas are very different and their priorities are different. And that's for any lawyer, even a domestic lawyer, you have to understand your client's businesses. But from an international perspective, you have to try a lot harder to try to understand the priorities of the business. Sort of connected with that, I also think a lot of international clients deal with goods and services, unless it's a financial institution. Even they deal with goods and services, but understanding international trade, understanding import export. You don't have to have a deep understanding, but to understand sort of the steps that the client needs to go through in order to internationalize their business, whether it's import, export, trade, shipping, especially now in the world with the supply chain issues. To understand the battles that the client is fighting that way is an important part to understanding their business. And then trade affects everything from tax, to duties and things like that really come into play in every sort of legal dispute.
Michael, to be sure, you are not suggesting that a lawyer should specialize in shipping, in trade, but just to have a working knowledge of these areas.
I would say a very basic working knowledge, or even know enough to ask the questions, or just keep a little space in your head in any matter that says, okay, I got to ask about this. I've got to make sure I understand sort of the trade issues. It's not enough to just look at the bottom line sales revenue, the raw materials price, or something like that, in calculating damages, calculating the costs. There's so much more involved now, and you have to ask those questions.
Sure. So we have identified technology, cultural fit. We have identified a basic working knowledge on international transactions, shipping, logistics, and so forth. Is there anything else that any one of you can think that would help a young lawyer or a lawyer that is going to enter into this practice area?
I think international practice, your project management skill, I think, is very also important, because this is like a multi cross-border transactions, and different lawyers from different jurisdictions involved. You may be acting as a lead counsel, and you have engaged with a number of sub-counsels. So how you manage their time and fees and clients' expectation, you cannot just delegate hands off. It's not the real the lawyer should do. You have to closely monitor what's happening in that different offices, different jurisdiction, even your juniors. So your clients engage you as a lead lawyer, lead counsel. You have to closely monitor and manage the project. So the project management is very important, I think.
Now, project management skills. Giles, you want to talk a little bit more about this area?
Yeah, I think it's when we started in working with international law firms about sort of 10, 15 years ago, I was working for various law schools in the UK. And the first thing they came to ask us about was, for their senior leaders, could we run project management courses? And of course we did. And the issue that they had, and we presented to partners at various law firms, and we did sort of half-days training on project management. And what quickly became apparent was that for each group of partners, they had a very different approach to scoping costs for a deal. We gave them a transaction to cost effectively, and who would they resource the deal and how would they do it? And what became very clear early on is that project management skills weren't just for partners. Whereas the partners should grasp the concept, and obviously we see the partnership partner as often a lead on the deal, it's actually the junior members of the team who have to understand that, going back to Hak Jun's point, that there is management at every level of an international transaction. And even as a junior lawyer, they have to manage the paperwork that's coming in, due diligence they're doing, the reports they're writing, the staff, the associate staff they're working with. So I think project management is absolutely key at all levels of the organization. And I think it's also understanding that it's not just you can use your software, your Microsoft project, you can understand your Gantt charts, you can understand your milestones. but understanding what lies behind it in terms of the resourcing. So when you're project managing something, you're managing resources, you're also managing relationships all the time. And it always comes back, I think, to this central skill of communication. That if you're going to be involved in project management, work very, very closely on your communication skills, your written communication skills, but also your oral communication skills and the way you relate to different people in different teams, maybe on an international transaction across the world. I think those are crucial things to make your project management skills really, really work.
Mm-hmm. That's a very good point, Giles, which reminds me, I have had occasions over the years to have to advise younger or junior members of the team. And one of the questions they always ask, and it seems to be an ongoing question or an issue, is this: how do I project manage someone who is senior to me? How do I manage a partner from another law firm in another jurisdiction? Michael, you have any thoughts on this?
I think you need to have a really good skill set under your own belt for your own area of expertise, and be confident in it, because you will find that the other lawyers that you're managing, either internationally or even above you, will grow to depend on you, and they will listen to you. It doesn't, at a certain point, a lawyer's not going to say, well, this lawyer's only been practicing 2 years, I'm not going to listen to this person because they don't know what they're doing. That's not going to happen if it's clear that the lawyer does know what they're doing. And us as we are more senior, we really depend on people to have that kind of project management skill and to be very good at it. I think you can do it as long as you're a good lawyer.
Jun, you were smiling just now and nodding your head.
I agree. Junior lawyers is very hard to manage, especially the international counsel, which happens to be senior than you. I think it's have some sympathy. It's very hard to manage that relationship. Yes.
Giles, any tips?
In terms of managing upwards, I think it's always about young lawyers watching very closely and learning. And it's a skill of watching and learning when you're in a group of senior lawyers and when you're coming into the team for the first time, understanding behaviors, understanding how maybe your supervisor or senior lawyers work. And to Michael's point, then having the confidence to do your own job really well, to understand your own area really well, to ask questions all the time without being over intrusive of your supervisors. If you do a piece of work, get feedback on it. Do it at a time and do it professionally and politely to ask your supervisor, can you give me 10 minutes to look over this piece of work I've done and tell me how I might learn? And that very quickly strikes a chord with the lawyers in the department. If they see a junior lawyer who wants to learn and does it in the right way professionally, very quickly, as Michael says, they'll grow to trust that lawyer, and they'll almost forget that they're only a year or 2 years qualified, because they're looking at the professional person rather than the fact they've only been doing qualified law for 2 years. And that's really important. A very important skill to do is to understand the environment you're working in and always get feedback on your work so you can constantly improve.
Thanks, Giles. The other point which I want to do elicit out of the panel is good design, good legal design. How important is legal design relevant to documents, to agreements? The concept of good legal design talks about it being client-centric, talks about, there's no point doing an opinion, a 10-page opinion that only some scholar somewhere hidden in some ivory tower can read and understand. You need to make it understandable for your client. Giles, I think you made a very succinct point earlier on that, in 3 sentences, what's your advice, so to speak, right? But that's making it sound a little bit simpler than what it really is. But good legal design, good design. What's your thoughts on this, Giles?
When I talk to law firms about and specifically designing courses for getting students to produce good, clear, succinct work and young lawyers, they always say the two hardest skills to master are drafting and research. So the research to build the understanding, the knowledge base to deliver the advice, and then the structure of that advice. And I think in this area, there's a real pitfall these days for young lawyers working in international law firms, and that's the precedent document. So you will often, to save time, quite rightly go to a precedent bank. These are documents that are being drafted by the firm, by knowledge lawyers in the firm, and they work very, very well in terms of the legal content, in terms of what they cover. However, often what young lawyers do is use a precedent as almost as a life raft. I've got a precedent document which someone's given me. It must be okay. I'll simply fill in the blanks. And you've got to understand the document you're writing. So when I see a young lawyer saying, well, can I use a precedent? I would just say, yes, but understand the document first so you know what to take out, as well as what you know what to take in. So I suppose my main point, Raphael, is understand the nature of what you're being asked to do. Don't be distracted by a document you're given to use that is a precedent document that may have clauses that aren't relevant to what you're using. At the end of the day, always think about, do I clearly understand the instruction I've been given? And what does that lead me to present backwards in terms of advice?
Michael, you're nodding your head.
No, I think Giles, what you said is absolutely perfect. I mean, you have to really tune the format of what your legal advice is going to be, whether it's orally or short document or something like that. That's just as important as the ultimate conclusion.
Sure. Thanks, Michael. Thanks for the word format. Now, I have seen work from international law firms, apart from the actual agreement that's forwarded to you as an attachment. Quite often, it comes along with a package as deck of cards, a deck of slides, where it uses infographics to explain the essence of the agreement and what are the salient points and so forth. I see that happening. I am not suggesting that's a growing trend, but I certainly see it happening. Is that a growing trend? Is that an aid and a guide to good legal design? Is that a good guide for clients to be able to understand that agreement that you have just drafted for them?
I think you're actually emphasizing another point that is helpful to understand, is that in various jurisdictions, that is, and for various clients, that is not helpful. In the United States, if you're going to give me a piece of advice that is not really good advice, that is not a good piece of, well, it's good advice, but it's bad news. I don't want a 50-page memo explaining why there's patent infringement in my product. In the United States, you don't send that memo. You make a phone call and you tell the person on the other side not to take notes, because in the discovery process and litigation in the United States, all that stuff is going to come out, and that document's going to be produced, and a jury is going to see it. And it's just, so you have to sort of tailor. Whereas in other countries, I think in Europe, for example, they don't have a discovery process like that. So you can go ahead and write all the bad news you want, I think, in something like that, and the client is going to depend on it. But in the United States, a fairly sophisticated client is going to know enough to say, don't send me that. So even you can't even send the client that and then have the client tell you no, because the cat's already out of the bag if you do that. So you really got to know what you're doing in that kind of thing. So that's why firmly understanding the format and the design of what you're about to send them, you have to sort of work out ahead of time with the client and fully understand that you may not be the right person to make that call. Like, for example, if you send bad news to clients all the time, because it doesn't matter, the moment you send something to a United States client, you should say, well, I'm going to call somebody who's barred in New York and has a New York bar license and ask him, should I do this? Before I recommend to the client that I'm going to do that. So a little thinking has to go in ahead of time.
Yeah. Giles, any thoughts?
I think Michael's absolutely spot on. And obviously, it's jurisdictionally, what are you going to send? How are you going to work with the advice you're giving? The technical process of getting that advice to the client. I think back to your point, Raphael, about, could you use other forms? I think if you understand the client, get to know a client quite well, and you're trying to deliver information, then there are other forms of documentation, and you might well realize that client is much more attuned to visual imagery. And for example, if you're trying to explain a restructuring of their companies, having a simple chart laid out of the old structure and the new structure is far better than pulling them through a 10-pager about, these are the companies and this is what you're going to do to them. So I think visual aids and different ways of presenting information are often helpful. But I think before you do that, you've got to understand, well, is this something the client will really value? To Michael's point, what does the client really want here? And young lawyers can do that. But I think look around and understand what your client needs first before you start moving away or using alternative forms of communication.
Anything from Auckland?
I also, from the cultural perspective, recently I have a case. I'm acting for a Chinese investor who wants to set up a finance company in New Zealand, Auckland. And we gave them like a 50-page what's the steps and procedure in terms of how to set up the finance company in New Zealand. And he came back whether we can ask like a one-page summary or like a diagram. So after that email, I sent like a 10-page diagram, PPT, explaining the procedure, only adding 2 sentences as a summary on each diagram. And they really appreciate that, because clients are always busy. They don't have time to read all the opinions. Lawyers are interested in the providing analysis, argument, all the risk, set out all the legal point of view. But clients want to know the conclusion. So either they want to have a conclusion in the beginning of our letter, summarizing like a bullet point, or some of the clients who doesn't really have that good English background, I think a diagram can really help them to understand the procedure better. So it depends on the client's needs and the cultural competence. You can think of it as alternative way of presenting your legal opinion.
Yeah, thanks. Thank you. Giles, one final question in terms of skill sets. You are familiar, Giles, with the concept of the OShape lawyer. Yeah. You want to talk a little bit about this?
Yes, and the OShape has really it's come from the profession. It's come from particularly general counsels in-house in international corporations, talking about when they see young lawyers coming in, often they hire in from private law firms. And those young lawyers come in from private law firms and are coming into in-house, into companies, international corporations within a business. And they are viewed very differently within the business. They are seen as business facilitators, not just simply as producers of legal advice. And they're very quickly having to work and understand all areas of the business, but also they have to have the competencies that make them a useful part of that business. And the OShape lawyers really come out of legal counsel and people like Dan Kane in the UK, thinking about, when I talk to business lawyers in business, in corporations, what do they want from a young lawyer? And obviously they want the legal skills, the nailed down ability to draft, write, research, etc. But they want more than that. And the OShape competencies are really drafted with a view to looking at things like emotional intelligence, things like we've taught team working, project management. Those are business skills. So you may call them legal business skills, but they are business skills. And the OShape competencies really address those. And they're, as I say, they're being publicized quite widely now. And a lot of law firms, when they are looking at young lawyers, will talk to them about, well, what competencies do you think you could grow and develop with us? What do you bring to our business? And so the OShape is really an attempt to draw together those strands of business competency that, added to a lawyer's skill set, should make you very, very useful within the business environment.
Thanks, Joe. Thank you very much. In practice, I mean, in the United States as well as in New Zealand and in Asia, do you, Michael and Hak Jun, see this as an increasing demand from clients as well as corporations?
Go ahead, Hak.
Sorry, can you repeat the questions again? I think I missed some of your.
Oh,
Yeah.
sorry.
Okay, sorry. The question is, I'm just trying to, I mean, Giles has just given us a very good example of what the OShape lawyer is, and is really very client driven, particularly from commercial organizations, the demands out of their in-house lawyers, for example. And of course, it's not just the in-house lawyers, but that's the same standard, that's the same requirement, that's what they demand of their outside counsel. I'm just wondering whether or not in New Zealand and in Asia and in America, is that the same similar experiences that you all are seeing in your jurisdictions?
I will rephrase that wording OShape competency as a sort of being a likable person. The reason why I'm saying this is that you know, international practice, you have to choose a lawyer in different jurisdictions you don't really know. And I assume all the lawyers has good legal skills, academic skills. And who are you going to choose? It's a big question, isn't it? Then when it comes to my practice, I choose a lawyer who is a likable person.
Yeah.
So someone who has a OShape competency is not just having the legal skills, but also has a business competency, and also someone has interpersonal skills and communicate well, and also can able to work together as a team. And someone who has that quality, being a likable person, I intended to work together. So I replace that wording as an OShape competency as being a likable lawyer.
That explains why you're so likable, Hak Jun. Michael.
Well, I think I agree with everything Hak Jun said, and with what Giles said. I mean, you know, the competencies are sort of soft skills that are very important in being successful in this area and meeting what your client demands are. And I will flip this one a little bit again, because I think it's important to emphasize, especially to our younger lawyers, that becoming competent in various areas of international jurisdiction or international law is something that you need to be attuned to and willing to do, but it's also extremely fulfilling in your career. It is a great thing to get to know. You can be a domestic lawyer and be focused on this very small area of law. And yes, there are specialists who just do that and they're perfectly happy doing that. But I think it makes for a very enriching career to be able to understand perhaps only the fun parts about foreign jurisdictions law, and also getting to meet people like everyone else on this panel through organizations like IPBA, where you can learn enough about these other areas of law, but also really make good friends and learn some of these soft skills that will make you an effective lawyer and very good at getting clients.
Oh, great. Thank you very much, gentlemen. I'm going to take 1 minute off to just speak to the audience. If you have any questions, please feel free to ask your questions in the Q&A box. We will endeavor to answer your questions in the next 10-15 minutes. There is already one comment which I will address later on, and then we'll float amongst the panelists to comment on it. Meanwhile, I have two last questions. The first question is this. We heard a lot about competencies, skills, opportunities, teamwork, project management, and so forth. How do you acquire these skills? Do you need to have a formal qualification? At the very beginning, at the start of this webinar session, we talked about the New York bar being I have not seen statistics, so I can't say anything. But I'll say that in many Asian jurisdictions, you see many lawyers that are dual qualified, one in their local jurisdiction and the other being the New York bar. In Malaysia, Singapore, for example, many of our lawyers are qualified from the English bar. But I think internally in Malaysia and Singapore, there is debate as to whether or not the English bar qualification is a relevant qualification for solicitors, for example, for transactional lawyers. Yeah. But that is an ongoing debate, and we will take another, not session, weeks and months to even discuss that. But having said that, I just want to ask this question now. As opposed to the New York bar, I know we know what the New York bar does. It is not just to familiarize oneself with Anglo-American type law. It gives you credibility within your own domestic market clients. But out of this, what are other more formal qualifications that are like the New York bar, which is available to us? And what are these, and what do they try to do? Giles, you want to take that?
Yes, I mean, very briefly, Raphael, in the UK, England and Wales jurisdiction, there's been a very recent change, and licensing and training for solicitors for practice has completely changed as from September of this year. Last year, apologies, 2021. And what's happened here is the regulator has very much looked at the New York bar and has looked there as an element there of a central examination, assuring standards. Everyone takes the same exam. And they've remodeled the English qualification system for solicitors to produce something, and we mentioned it in our discussions before this seminar, the solicitor's qualifying examination. And that will be the only route to qualifying as a solicitor in England and Wales from this year. And there are transitional provisions. The old model, the legal practice course, is still running. But what does that mean for young lawyers in our jurisdiction who are training? Well, it means that they don't have to have a law degree to qualify. They have to have a degree. They have to be a graduate. But they have to take this national exam. This national exam gives them a foundation in the legal knowledge that the SRA say they need, but also the legal skills. So there's an emphasis on the legal skills and the core skills we've talked about in this presentation: writing, drafting, research, presentations, etc. And also, to qualify, candidates have to think about getting qualifying work experience, actually working for 2 years in an organisation or organisations to get practical legal experience under their belt before they qualify. So in terms of the demands on young lawyers in the UK, the real change has been to look at a much more practical training. And I think if you're looking, as we said before, there is no qualification as an international lawyer. But if you're looking at formal qualifications that can give you the skills and understanding to work in a particular jurisdiction, you should think very seriously about that. And in the UK, that's the recent example of how they've changed the training regime to make it more practically focused.
Giles, I just want to pick on one point. You said that having done the exams, you need to spend 2 years in a law firm. Now,
not necessarily in the law firm, Raphael, and that's where the regime has liberalised. Under the old regime, yes, you had a training contract for 2 years with an organisation. It could be a law firm, it could have been a local authority that practices law, has a legal department. Now the definition is much wider. You're gaining something they call qualifying work experience under the regulations. That can come with up to 4 organisations. They don't need to be law firms. The common denominator is it needs to be signed off by someone who is a solicitor and who has an understanding and knowledge of the work you've done. Now, as you can imagine, this is so new for England and Wales that there's still a lot of discussion with the regulator as to how far and what sort of work is covered. So, for example, we know that if young lawyers are working in law centres or working in law clinics, that work, if properly supervised, could count as qualifying work experience towards that 2 years. If you're working in in-house department and team and being supervised by a solicitor, the same would apply. So it's a much wider definition of what qualifies as work experience.
Okay, thanks, Giles. One follow-up question from there would be this: if there was a young Japanese, Korean, Malaysian, Australian, for example, any that has taken the SQE, do they need to come to England to do the 2-year training?
No, program? They don't. That's again the other change in the regime, is that you can obtain your qualifying work experience wherever you are in the globe, provided that is signed off by a solicitor or signed off by someone outside your organisation who has knowledge of the work you are doing. And that, of course, is for international law firms, is very, very important. We've been talking to law firms in various parts of the world where they have several young lawyers they want to qualify under the English system. And it's setting up that system of supervision within their international office that satisfies the regulatory requirements.
You said supervised and signed off by a solicitor. Do you mean the legal definition of solicitor of the UK and Wales, or sorry, England and Wales, or is?
Yeah. They don't have to be a practicing solicitor in that area. They simply have to be qualified as a solicitor.
Okay, so that's where perhaps the limitation would be.
Yes, exactly. Yeah, yeah. But that's what we're finding is in talking to law firms based, for example, in Singapore or Dubai, etc. There is usually an individual or individuals in the office who has that qualification, and they're making sure that individual is then put in the role of supervisor to understand what's being done. And the controversial point about the regime, and apologies, this is such a change that it would take another seminar to cover it. The controversial point is the supervisor is not signing off the quality of the work. The supervisor is signing off the fact the work has been done. That's causing a lot of discussion among law firms because they obviously want the work they sign off to be of a quality, and they would do that. Under the regulations, it's actually about signing off the fact the work's been done rather than the level of the work.
Thank you. Michael, do you have any questions for Giles?
No, I am struck by, look, I've always admired the English system, and I think it's learning by doing is so critical. And in the United States, we're really so far away from that in terms of qualifying to be a lawyer in that way. You know, I think we can learn a lot from the way you do it in the UK in this historical system. I mean, I think it's so much better that way.
Hao-Jun, you want to say something?
Yeah, I mean, still the university's legal education provide too much emphasis on the academic skills, and students are worried about passing the bar exam. Having that experience in the real legal office or practice will definitely equip the student to become a good lawyer, I think.
Yeah, thanks.
I think what we've found to that, and that's talking about students, is students are looking now not so much at the formal qualification of being a solicitor, but often students will now join law firms in a junior role and gather the experience, knowing that at some point, having banked their qualifying work experience, they could go to their employer and say, I now have this experience, you know I'm a good employee, could you please help me to qualify? So actually it's opening a completely different door to a sector of employees who've worked in law firms for years, not having the official badge of solicitor, but really competent, really driven young lawyers who can now gather this work experience and have a framework through which to go and qualify.
Giles, there are two questions here for you, Giles. The first question is, can you please tell me more about the new SQE exam in the UK? And the second question is, can foreign lawyers sit for the UK SQE exam?
I'm aware of time, Raphael. So if the individual, I don't know if it's possible, wants to contact me directly, they can. If you can pass on my contact details, I'm very happy to do that. The second
but in
point,
one sentence.
Yes, they can. To the second.
Yeah, but can foreign lawyers sit for the UK SQE?
Yes, they can. Okay.
Just rounding up, there is a comment from Ronaldo Ma from Brazil, where he says super early morning. And his comments is these: there are no internationalization of legal practice, but localization of multi-jurisdiction deals. Anyone wants to take comment on this? there are no internationalization of legal practice. There is no legal internationalization of legal practice, but localization of multi-jurisdiction deals.
It's sort of the reverse of the way that we described it, I believe. But I think it's a good way of saying it.
Yeah.
Yeah.
Thank you. And I think there was another question about what are you looking for in young lawyers? I think we talked about it. I think it is not just one skill. There are multiple skills. We talked about it from research, drafting, interpersonal skills, project management skills, cultural fit, and so forth. So a wide range of skills that really are required. Now, finally, gentlemen, as we close to bring this session to a close, I just want to ask this question, and I want to go around the table. The question is this: how would you advise young lawyers or lawyers that are looking to break into this area, the practical steps that they should take in order to be able to break into this area? Anyone?
From my point of view, I would very quickly make use of networks. I would very quickly join your local law societies, join networks, organizations such as this, to really start to communicate and to network with other young lawyers.
I agree with that. And in addition, I think it's very important to focus on your domestic area too. Be a good lawyer first so that you have something to offer others jurisdictions who would want to come to you and want to work with you.
Thank you, Michael. Good.
My advice will be joining a right firm to start with. I think it's very important. Practice internationally requires a lot of resources and skills and guidelines. Maybe you have to travel a lot, and the firms has to support you. So choosing a right firm who can support your practice, I think is very important.
Thank you very much, Hong Jun. I'll just say this as a concluding remark, is that my practical advice is, apart from the law, which is a given, apart from drafting is a given, I think it's very important that young lawyers or lawyers that are trying to break into this area to be open-minded, to read up on international transactions, trade, commercial things, learn to read a balance sheet, for example. All these are very, very important. And finally, of course, I echo all the speakers, either join a good law firm that does some international work, but more importantly, this is something that is within your control, is to join an international platform, international organization like IPBA, where you can meet many other lawyers that are doing the same thing as what you want to do, and that's how you build those contacts, those connections, who will really, in time to come, provide you with the opportunities. Having said that, ladies and gentlemen, thank you very much. I just want to take this time to thank our members of the panel, Giles Proctor from London, Michael Chu from Chicago, and Lee Hak Jun from Auckland. Gentlemen, good day and good night. Thank you.
Thank you, everybody.
Thank you.